CR1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in J-Haas versus AZDFI, our cause number 1CA CV130546. Counsel, we have conferred about this case. We're very familiar with the briefs and the record, so you can bear that in mind as you begin your presentations. Each side will have 20 minutes, and the appellant you may reserve as much time as you wish for rebuttal, but you're responsible for watching your own clock. And I think I'm required to tell you that we're being videotaped during this oral argument. And with that, we can begin.
Good morning, Your Honors. My name is Tim Barnes. I have been the attorney throughout this proceeding for the appellants in this matter. I'll tell you that notwithstanding many years in front of the bench, it's a little more nerve-wracking when I come to this court or to the Supreme Court. So it's the butterflies are there, and the butterflies are there, but. And I am mindful, Judge Swan, that I want to reserve a chunk of my time for rebuttal, so I will be watching the clock closely. We put a good deal of thought into how to present this, both in terms of the written briefing and the oral argument, because I well know, especially in this court, that the court has spent a good deal of time looking into this, had some research, and has met on this. So then the question becomes, all right, how am I going to approach this? And what
Mr. Burns, let me help you out. What's the purpose of the debt management statute?
The purpose of the debt management statute, Judge Brown, is to ensure that companies who receive and disperse money are following the regulations.
Should it be broadly construed or narrowly construed?
Well, I think that obviously there are an awful lot of statutes that are, depending on what the function is, they can be broadly or they can be narrowly construed. From my perspective, I don't think it needs to be overly broadly construed, but I think there's certainly, you can't just look at those words and say, well, based on those words, we know exactly how we're going to construe it.
And why does the department require licensing of these types of companies? What's the end of, what's the end of the game
Your
purpose?
Honor, that's curious to us because there are a good number of the debt settlement companies that are here in Arizona, and to our knowledge, we're the ones who were singled out. So I can't really say for the department. I think the department can talk to that.
Well, you define it as debt settlement companies. That's not what we're talking about here, is it? I mean,
the
statutes around debt management, and we have a specific set of rules, and aren't those rules crafted for the purpose of protecting people who are struggling financially, debtors who need help?
Absolutely. Absolutely they are. But at the same time, if you look at the individual components of the statute, a primary component of the statute, I mean, I'll just go through the six, although I know that the court has gone through those. The first one we say is obviously if you're receiving compensation, there's no question there. The second one is you're engaging in the business of receiving money or evidences thereof. Now that phrase, or evidences thereof, if you look around the country, that phrase is actually used in a fair number of, that phrase, evidences thereof, is used in a fair number of state and federal statutes. We could not find any one case who said, all right, for evidences thereof in this context, here's what it means.
Well, doesn't it essentially mean accounts? I mean, this is old language, and it used to be that money was a tangible thing that you could physically hold. That's rare these days. Doesn't evidences thereof simply mean evidence of your ownership of money in a financial institution?
To a degree, but then you have to overlay on top of that, Judge, the notion of how do you have the access to that money. Obviously, if it's cash, we know. We've got cash, we can hold it. If the money's in the bank, then how does someone have access to that? Well, obviously, the account holder has access to it. The bank has access to it. And then the account holder gives access to any other company, typically through an ACH type of transaction. And the ACH transaction in this instance was done between not J. Haas Group, but it was done with Noteworld on behalf of.
And that's my question. If Noteworld hadn't been injected as an intermediary, would you concede that J. Haas Group is subject to the licensure requirements of the statute?
If they were receiving and dispersing the money, no question about it.
Okay, so Noteworld is the key to your client's position.
In part, it is, yes.
What's the other part?
Well, in part, vis-a-vis the statutory construction, Your Honor. When it comes down to the substantial evidence, that's a different issue. And
Statutory construction.
I'm sorry. When it comes down, I misspoke. When it comes down to the substantive evidence as to whether or not there's sufficient substantive evidence, that's another key to ours. But certainly, in terms of the statutory construction, Noteworld is a key to.
Okay, and from the consumer standpoint, what's the difference? What is Noteworld doing that increases consumer protection any more than if Noteworld didn't exist? It strikes me, frankly, that Noteworld is inserted to create a formal distinction, not a substantive distinction.
Well, I disagree there, because if you look at what the evidence disclosed, and I've set that out in my statement of facts on consumer control, and if you look at some of the other evidence that's in there, there's no question that the consumers had control over that account. And Noteworld assured that by sending out a welcome letter, by having certain requirements that are on there, and then Dorian Maycumber testified that there were certain things that J. Haas could do and certain things it could not do.
But if J. Haas were holding the money in its own bank account and doing exactly the same stuff and send out the same welcome letter, it would be subject to regulation. But because it uses Noteworld instead of Wells Fargo, suddenly it's not subject to regulation?
No, Your Honor. What it comes down to is if the client, I mean, this comes back to this notion of whether or not J. Haas is in the business of receiving money and then dispersing that money to creditors. Okay? And because, there is very little authority around the country on the management of companies under state regulations, these kinds of companies. California is the one state where there's been not a lot, but minimal authority. And that's, of course, where both sides cite the court to Nationwide and to the Estrella case. The Nationwide case was simply an administrative appeal, okay? The Estrella case was actually a lawsuit filed. But the administrative appeal, the Nationwide case, they said, look, we're going to, and it was the same concept there, where there was a different, it wasn't Noteworld, it was, I don't really remember the name of the company, but it was a different company. And what the California court said is, look, among other things, we're going to look at whether or not the consumer had control, because if they had control to countermand anything, then we have to consider that.
Anything. If they could countermand any single thing.
In terms of how their money, what was happening to their money. I was oversimplifying, Judge.
Okay.
So if they could countermand instructions with respect to what happened to their money, then in fact, the court said we're going to look closely at that. And then you get to the Estrella case, and the Estrella case is in district court, United States District Court. And the district judge there was ruling on, I don't know if it was cross motions for summary judgment, but it was a summary judgment context procedurally. And the court there was very careful about what it said, and it honed in on whether or not in California they're called prorators. They're not called debt managers, okay? Whether or not the prorator, whether or not the consumer had the ability to countermand what was going on as far as what the prorater was doing with their money. And so there they said, we're going to look and see how much ability did you provide the consumer. So to that end, Your Honor, this is a long-winded way of working my way around to the point of the court, is that it does matter what the consumer has the ability to do.
Okay. So you would, taking, I guess, the glass half full approach say if the consumer has some control, then there's no receipt. And I expect that the state might take the glass half empty approach and say if JHAS has control, then there is receipt. Fair characterization of your disagreement?
Not entirely, because I think you've got to look and see what kinds of control or ability to countermand did the consumer have. Because, for example, in the Nationwide case, well, not so much in the Nationwide, because that one I don't think they didn't develop the facts. But clearly in the Estrella case, there was a power of attorney given to the prorater. And that power of attorney says we get to exercise all discretion in what to do with your money, whether it's to pay ourselves or whether it's to settle. And in that instance, what the prorater did was just say, that's what we're going to do.
Okay.
Now,
and that's a legitimate distinction, I think. What you're now getting, I think, to the purpose of the statute instead of just talking about the abstract meaning of a single word, which I appreciate. And to emphasize that, it seems to me that the word received is probably not the word that the legislature thought was the core of this statute. I think reading the whole statutory scheme, what the legislature was concerned with was businesses who control other people's money for purposes of handling their debts, right? It wasn't the receipt, it was the control.
It was in part the control, but the statute reads it's received for the purpose and then of dispersing. So you're receiving the money and then you're dispersing the money.
If receipt is not defined by control or level of control, then what is a better definition? I mean, I don't recall that you would put forth a specific definition in the briefing. Perhaps you did, but no. What would you suggest if we can't define that? We've got to define this term somehow, receive. And if it's not, from what I thought you just said, you said we need to look at the level of control that the client exercised and the JHAS exercised, and then make that determination. So it seems like you're suggesting that that control is a word that could be substituted in there, or at least to help us in defining receive.
I think that's right, Judge. If I may ask, how much time have I used?
You got 9 minutes left.
Oh, 9 minutes left. All right, thank you. I guess I should pay attention. The California courts looked at the level of control not just as an abstract, but they said in the context of what you pay yourself for the fees and where you disperse the money on behalf of your client. And so in this instance, and the California court, and I'm quoting now, says the defendant must have, quote, sufficient control over customers' funds to permit disbursements both on behalf of clients, which would be for settlements, and for defendants' compensation. So they're looking at control on both fees and the debt settlement portion of that, which is obviously part and parcel of the statute.
But didn't the backdoor access that JHAS had to NoteWorld constitute that sort of control?
Not at all. Not at all.
How so?
Because the back door that they're talking about is only talking about the fees. And I'm going to reserve my time here shortly, but I want to finish answering this question. If you look at they had 7 extensive powers is what the department is talking about. And if you look at those extensive powers, I was very careful in my answering a reply brief to go and show you how that had everything to do with the payment of fees.
But isn't that a distinction without a difference?
No.
They can get into the account. They can take the money out that they want to take based on the amount of fee they think they're owed. You've got complaints from old customers who say we thought we were going to get money back, but JHAS ended up taking all the money because of alleged costs or expenses or whatever that were a part of their handling of this account, and they didn't get anything back.
Well, the California courts both said you've got to look at what they were able to get for fees and what they were able to control for disbursements, because you'll see that the disbursements for settlements are the more substantial than the disbursement for fees. And so the California courts have drawn that. So to go back to Judge Brown's question about control, it seems to me it's got to be control over both the fees and control over the settlements for the creditors.
Counsel, why did JHAS charge a fee for trust administration, administering the funds, if they weren't in control of those funds? I mean, what was the purpose of that fee?
Your Honor, I can only tell you that the evidence and the testimony, and I can't quote line and verse, but I can tell you there was evidence that that fee was not paid to J. Haas. It was actually paid to a third party in the whole scheme of how they set things up.
A third party other than Noteworld?
Yes.
Well, other than Noteworld.
Paid to Noteworld. Some of that was paid to Noteworld. It was split between Noteworld and the marketing companies.
I'm not sure that helps your position, though. I mean, getting back to Judge Brown's question, what is the purpose of all these fees if there's not some service being provided?
Well, there is.
The service, as I understand it, is the administration of funds.
No, the service is the settlement with the clients. That's the primary function that J. Haas dealt with.
So then, rather than having a fixed entitlement, a benefit to be gained from settling this matter with this creditor, they just get a percentage of every payment that is made from then on until the creditors are paid off?
No, they were paid a couple of different ways. There was a set fee, and there was a percentage of the settlement that was made and the savings that was realized. So the more clients, the more creditors you settled with, you had a larger fee that would be paid in that fashion. But apart from that, there was also a fee that was paid on an ongoing basis. And from J. Haas's standpoint, they have ongoing expenses of quite a number of employees and the software and just the kinds of things that businesses have.
But not for this client. I mean, once this client's issues are fixed, once those numbers are set, are they continuing to administer and run operations for the benefit of them, or does the thing just then take its path?
I mean, they certainly have. They have a whole negotiation department, and that negotiation department is responsible for negotiating. You just never know when somebody's going to call in, so it's not really fixed because.
But the negotiation ultimately has a conclusion, and we're assuming in the best case scenario that it's a successful conclusion where J. Haas negotiates some lower payment to a creditor. Once that negotiation is complete, why should Noteworld have the client's money? Why doesn't the client just pay according to...
The client, and there's evidence in my briefs, that Noteworld testified anytime a client wanted to take their money out, they could do that. They had that ability.
I understand, but if they leave it in, they're going to keep paying fees, and presumably they're paying fees for something. Not something that happened in the past, but something that they're getting.
Because the contract called for ongoing fees, and I'm going to ask if I can here,
you may.
Because I have 3.5 minutes left. I apologize. Thank you.
Reserve those for you. Thank you.
Good morning, Your Honors. May it please the Court. Natalia Garrett, Assistant Attorney General representing the Arizona Department of Financial Institutions, and Superintendent Lauren Kingery. I will jump into the fees issue because that's how the department learned about this case, consumers complaining about the fees. And tied with the court's question as to why is the statute in place? What does it do for consumers? One of the many protections that consumers would receive had J. Haas had a license was that a prohibition on paying any bonus or other consideration to any person for referral of a debtor to such a business. So what was happening here is you actually have J. Haas, unbeknownst to consumer, splitting its fee through the control group mechanism established with Noteworld to some other companies. And consumers essentially not looking at some of those statements and not understanding where their money is going.
So Noteworld was an escrow agent, not a bank, correct?
That is the license type that they held.
And Noteworld had these arrangements and allowed J. Haas to come into their computer system through what's referred to as a back door, so J. Haas could effectively move Noteworld out of the way and process its own accounts and handle its own debits and whatever, correct?
That is correct.
What's the distinction between Noteworld and J. Haas?
There isn't. That's the department's position. And the two companies acted as one and the same. It was pretty astonishing to the department.
And in fact, they split fees.
They split fees, and it took a while for the department to elicit that admission from Noteworld. And once the department found out about it, what essentially is going on is that Noteworld is renting its payment processing software to JHAS, giving it essentially unfettered access to the trust funds in the Noteworld account set up for consumers. But the importance of this case and why this case should be affirmed is that the legal principle in this case spans across many different license types that the department supervises. You have JHAS who evaded regulation designed to protect vulnerable consumers in debt, and JHAS engaged in the precise conduct that regulation targeted. JHAS claims it was the debt settlement company, not a debt management company. But quoting Robert Charlton, Assistant Superintendent, what you call yourself is not really definitive of whether or not you need a license. It's really more what your activities are. Putting on a pair of gloves to hide fingerprints, ultimately the dots will be connected. If you have a company that reaches or has access to consumers' checkbooks, it's likely that this company needs a license. And the test for whether you need a debt management company license is not who was the last company that touched the money. It's rather what entity was in control of those decisions when the money goes in and goes out, who has the strings, who has the trigger button. And we have tested...
Counsel, so let's jump right into control. So are you saying that control is the key word, if you will, the key word that we need to look at to determine what the meaning of receive is?
Yes. Department's position has been in construing the phrase receipt of money or evidences thereof. The sentence does not end there. It goes on to state the purpose of this activity. The purpose of receipt of money is for distributing the same to creditors in satisfaction of debt. So why is the statute there? The ultimate result that this company is hired to accomplish is to pay creditors. So it's about the result. It's about not how it's accomplished. So therefore, you have a phrase, money or evidences thereof. The legislator signaled that it is not reduced to the word money. So your question today is, what is debt management company? Should it be just a company that holds the money or the company that has access to the money? The department's position is that the result is the same. In either case, there is a potential for mismanagement of the funds, as happened in this case. And
well, okay, can I, as long as we're still on the topic of control, though, let's take the glass half empty, glass half full approach, or argument that we have. We have shared control, I think, over this money, right? The consumer has the ability to pull the money out. JHAS has the ability to direct the disbursement of the money if the consumer doesn't intervene. Am I right so far?
The consumer does not have at all the same control as JHAS. JHAS has many more rights toward those funds than JHAS.
Well, their rights are more numerous.
Their only control that we found out that they had is to get out of this program, to demand refund and close this program. And even then,
right?
Well, it is important, but even then, they don't have the right. The last word, as we found out through declaration of John Proscia, is that.
Okay, but just getting back now to the legal definitions, if each of them have some rights of control, they may not be the same rights, but the consumer has an ultimate right of control. Do we look at it? How do we know whether to look at it through the state's lens and say once the debt ellipsis company has any control, it is receiving money, or does it need exclusive control?
Right.
What language in the statute can guide us to a conclusion on that issue?
I guess you could view it, as you said, what are the money, the funds in the account. You could analogize it with two people that are co-signers on the checking account. If you have more than one person that can take money out of this account, that's sufficient control. And you can also rely on California cases as persuasive authority if you wished, that specifically addresses that and says you don't need exclusive control, sufficient is enough. In this case, we say that the evidence in Estrella was missing to find summary judgment of unlicensed activity. The court said there's no evidence that a debt settlement company actually hired payment processing company as a straw man to disguise this activity of actually accessing funds. And it says it in Estrella on page 1049. We submit that the department has presented that very evidence that was missing in Estrella. Should the court want to use Estrella as some kind of blueprint as persuasive authority, we have evidence of Note World exercising, using Note World as a straw man, as a entity, as a facade. So I guess you're asking where to draw the line. We think sufficient control is probably acceptable.
Sufficient control? I mean, I understand your cosigner analogy, and that makes a certain amount of logical sense. But what would sufficient versus insufficient control be?
Let's go back to my point on read the words together for the purpose of distributing. Was it sufficient enough for them to be able to accomplish distribution of funds to creditors? And here we submit that evidence is plentiful, not just sufficient, that happened. You have a Note World testifying that when Jihaz had access to Note World's computer system, they were entering information. And that information included not just bank account information, not just the name, but it also included debit schedule, and it also included the, quote, allocation or the disbursements to creditors, although that most likely did not happen at the time of the settlement of the account. And
so
that's...
Hold on. So are you saying that they went into the Networld account and made the disbursement and credited it in the account? Or are you saying that a disbursement was made and at some point then they came in and updated the record?
They triggered it. They started it. They initiated it.
They started it, what, similar to an email?
Similar to probably more direct than email.
Is this more like a bill pay system, like when you use your own personal checking account, you can say pay these bills in the next month, and it just does it? Is it sort of like that?
That is certainly how an explanation we received from operations manager of Note World, that explanation that came through, that administrative law judge relied on when he made the finding that Jihaz disbursed funds. But aside from that witness, we have consumers. Not only consumers, we have Jihaz's own letter written to a consumer. Let's say Exhibit 1, Vicky Bernardi, where Jihaz says, we made a payment on that settlement from your Note World account, and we set up a check by phone to pay remaining balance term. We reduced your payment to Jihaz to assist you. So clearly, this is not just a debt settlement company. This company does what its agreement says. It assists in facilitation of account payoff process. It charges a fee for it. It admits to doing it. There is more than one smoking gun in this case. You have your agreement. You have ACH or sign-up agreement with Note World. And that is authorization that essentially consumers gave to Note World to debit their checking accounts. That says that the debit should occur according to the schedule of debits as provided by me on my behalf. And here is from smoking gun to smoke and mirrors. What is the schedule of debits? When pressed, we find out that there is no such document that exists. That in reality, the schedule of debits was very process that existed for jihas to go indirectly into the payment processing system and to set up these debits. It gets even more interesting. If you look at the ACH agreement, it tells you, you're a consumer, your first initial payment to Noteworld will be, for example, $500. However, there is nothing as to what your next payment's going to be, when it's going to end. Guess what? It is the jihaz who is now sitting at the computer directly at Noteworld, has access to debiting consumers' personal checking accounts, and decides. Granted, consumers agreed. I'm not saying.
Sorry, consumers' personal checking accounts or consumers' accounts within Noteworld?
Both. That's the beauty of this case. When you have the setup of the schedule of debits, they decide they're taking the money out of personal checking account into Noteworld trust account. So that's the first thing. And then where does the money go? Two things, fees and reserves. Fees is an excellent issue. I agree with the point that I think was made earlier, that this admission by jihaz that there was exclusive control over fees is not to be neglected, because the fees weren't pursuant to a separate agreement from a different source. It was right there from the same accounts.
Okay, so if you go into the J-Haas Networld arrangement and you put $500 in, which is the initial requisite payment, right?
Yes.
Is there a delineation between what portion of that is for fees and what portion of that is to go to creditors?
That is something that J-Haas sets up. As the testimony shows, there is a delineation as to how much percentage is going to go to J-Haas, how much is going to stay, and apparently further, whatever goes to J-Haas then gets split into some other companies.
Does it come out of a separate fees account versus a payments to creditors account?
It's one account. That's why we analogize it with commingling. And that's why we say if you admitted, J-Haas, that you had exclusive control over the fees, it's the same. It translates directly in the admission of control over the rest of the funds. Because if you take everything for fees, there's going to be nothing left to pay to creditors. And that's actually what happened. That's what happened, because when the time came to pay creditors, everything went to fees. And then consumers were getting phone calls saying there's not enough. Can you come up with more? And then they had to do setup checking by phone, where they had to engage whatever money consumers had sitting in their personal checking account, and J-Haas did that as well. So it started directing money directly from personal checking accounts to creditors. As you will look at the declaration of Elaine Christensen, where she says, I can't put up with this. I can't pay money to you and to the Chase Bank. And they said, okay, well, we can either maybe refund you this month since you're in a hardship, or how about we'll just reduce the money we're going to pay to Chase, and instead of $150, we'll pay $500 and pay $1,000 out of Noteworld accounts. So there's a complete control and decision-making authority with J-Haas that consumers did not have over what would be happening with these funds.
Okay, so instead of J-Haas simplifying or reducing their debt load, what happens is J-Haas just becomes an additional creditor, but they become an additional creditor to be paid first out of monies available.
That is true, and we almost wanted to go there as well, because that would be even a stronger argument, but the statute does define the term creditor to exclude licensee.
But they're not a licensee.
Well, there you go, actually. That's a good point. So they should have been a licensee.
But as interesting as that argument is, does it potentially prove too much? If your argument is that they should have been licensed, does that translate then to the activities they're doing are not subject to licensure because of the licensee exception, or does it translate to once you get your license, then you're in violation of your license on day one?
No, it wasn't an exemption. You may have heard me incorrectly. Okay. You could probably just look up the definition section. As a matter of fact, if you did want to talk about exemptions, issue wasn't raised, but if you wanted to be intellectual about it, there is an exemption for billing providers services that don't need a license. But interestingly, that exemption makes reference that the legislator knew between receiving money and just having checking writing authority. And it says you may not need a license if you're just paying bills but you have to meet all of the criteria. And it means you cannot negotiate that. So they do not fit within that exemption. They did not invoke it. But it's something that if
Counsel, are you saying that there's two worlds? There's a world in which you're licensed, and then there's a world in which you have an exemption, and you either fit one or the other?
Correct.
So you're saying it encompasses everybody in the universe? Every company would either have to be licensed or fit in exemption?
No. Well, every company has to read the license.
I mean, any company that's handling, you
have to be,
because obviously what Jay has tried to do here is set up a business model that came right down the middle. It didn't fit either one of the two worlds. That's what their argument is, right?
Right. And it was an argument to disguise. And of course, the department looks beyond that. You cannot come up with models to disguise. And in terms of exemptions, again, for them to apply, if you legitimately fit the criteria that puts you within exemption, the department will not be requiring a license. But that's not the case here. So you just carefully analyze the definition. Does that address your question?
Yes. I'd like to go back to Judge Swan's earlier question. You said sufficient control, but I'm still struggling with sort of the level of control. I know the ALJ talked about control. The ALJ also referenced constructive receipt, constructive possession. If you were writing this decision, what terminology would you use as far as significant control, sufficient control, substantial control? I mean, almost put it, is it preponderance of the evidence of control? Like J-Haas needed to have 51% as opposed to the client having 49%. This is a difficult, if you can imagine, this is a difficult to write. So how would you suggest that be done?
I mean, I guess some cases just have to be analyzed case by case, but you would again have they accomplished the purpose? Were they the ones that making the decision when the money comes out? Were they the ones that were fulfilling that mission of sending money to creditors? And just to conclude, since my...
Well, I appreciate what you're saying, but I want to make sure that we clarify one thing. Is the logical implication of your position that any control is really sufficient? To go back to your cosigner analogy, let's say the consumer had most of the control, but J-Haas still had a little bit of control. Is that enough?
I think that that is addressed in the exemption, because if you study legislative history of that exemption for bill service providers, that will tell you that there was some companies that said, listen, we don't think we need a license just because we are helping somebody with debt and we have this check writing authority. And there was an exemption created for them. So I think that addresses your question. But since I have just a minute left, if the court lets J-Haas prevail, then it would be given a roadmap to all kinds of entities to come up with even bigger and better plans to disguise the true nature of their business and to avoid the application of the law. We ask that the court not do that and affirm the final decision of the superintendent.
Thank you.
Thank you.
I woke up this morning on a swollen foot, so I'm slow coming to the bench. You know, I want to go right to, I've got 3.5 minutes. I want to go right to the point, Judge Brown, you were asking about, all right, what's the control? To me, the control is, to what degree does the debtor, the consumer, I should say, have the ability to countermand any kind of disbursement? And with that in mind, I would remind the court that in my brief, I quoted
Counsel,
from...
let me just ask you, is that on paper or in practice?
Both, because it seems to me, and Mr. Charlton, who's a deputy superintendent, he testified, and I'm quoting now, the opportunity was there for the consumer to understand about the Note World account and what rights and access and everything they had regarding the Note World account. And then on page 21 of my reply brief, I talked about Elaine Christensen, one of the witnesses she talked about, testified that when she got the welcome letter, she understood exactly what she could do. So I don't think that you can say that if they have the knowledge, if they're given the opportunity to understand the control they have, and for whatever reason they choose not to exercise it, I don't know that you can, where you draw that distinction.
But counsel, doesn't that cut against the people who complained that they got out of it? They exercised the one thing that Judge Swan suggested they had the right to exercise, which was to get out of the program. Then they waited for their money to come back, only to find that they had no, that they had no control over the money that came back because J-Haas says you don't get any money back. So how is that control?
Your Honor, I can't speak to one or two individual ones. We're talking about one or two individuals that were testified to. Dory Maycumber from Note World testified, and this is on page 22 of my reply brief, that those clients could stop any payment to J. Haas Group in any particular month. They could take the money out of their account without first clearing it through J. Haas, and that they could J. Haas could initiate transactions in the system to refund for one of its clients, but J. Haas couldn't actually disperse any funds. Now that's what Dory Maycumber testified, and the difficulty I have with some of the questions and answers in the department's position is the department would have you think that because J. Haas had in a back office, if you will, control of fees, they did that. They did, and we've said we're not contesting that. But that's all they had. They didn't have any control over the disbursement of the funds because Note World required that there be a settlement letter, and J. Haas, and this is undisputed, had a procedure whereby if that settlement letter wasn't approved by the client, then the settlement wasn't done. And each of the 5 witnesses, consumer witnesses, came and testified. Each of them had settlements, and in each instance, they approved the settlements, and that's the basis upon which the disbursements were made. So this takes me back to the California court saying, look, you've got to look at the ability to control 2 things. One is the fees and the other is the disbursements. And I don't know that you can draw that line very clearly on those. We're not disputing that we control the fees. We've said that multiple times in my brief. You know, there was a lot of moaning and gnashing of teeth, you can imagine, from the client's perspective, but I said, look, that's just a fact. But there's got to be more. There's got to be control over the disbursements of the settlements, and that's where the big money went. And I say, I'm done.
Well, thank you very much. Appreciate both counsel's arguments. This matter is now under advisement. We will issue a written decision in due course, and the court will stand in recess to allow the next case to set up. Thank you.